Madam Speaker, H.J. Res. 17 is not a resolution to revive the Equal Rights Amendment. It is a messaging vehicle. That's why Democrats bypassed the Judiciary Committee and brought this resolution directly to the floor, a common theme for this majority. There was no process for this resolution, a resolution that Democrats claim is a priority. We are here today for a headline so that Democrats can say they supported the ERA when it was in the House. But the fact is, Madam Speaker, that men and women in the United States are already equal under law. The 5th and 14th Amendments to the Constitution require as much, guaranteeing equal protection for all under the laws of this country. To me, the ERA is unnecessary, redundant, and divisive. The only thing it will do is empower the far-left special interest groups to lead to activist litigation. Just last year, the head of Planned Parenthood declared, and I quote, "There is no equal rights for women without access to abortion, plain and simple." Or according to NARAL Pro-Choice America, with its ratification, the ERA would reinforce the constitutional right to abortion. We should take them at their word. For years, groups like Planned Parenthood and others have advocated for the adoption of the ERA so they can use it to pursue their pro-abortion agendas. If the ERA became law, it would allow these organizations to advance their radical policies through the courts without being in full view of the American people. These groups have hijacked the ERA and are seeking to use it as a tool to challenge states' pro-life laws. But the reality is that this resolution is unconstitutional. Article 5 of the Constitution empowers Congress to propose amendments to the Constitution by a 2/3 vote of both the House and the Senate. After Congress proposes an amendment, the amendment is sent to the states for ratification. 3/4 of the states must ratify the amendment in order for it to become effective. The Equal Rights Amendment was proposed in 1972. The amendment set an explicit deadline. It gave the states 7 years, until 1979, for ratification. Setting a deadline for ratification is part of Congress's authority to determine the mode of ratification under Article 5. In 1920, the Supreme Court held in Dillon v. Gloss that there was no doubt that Congress can set a date for ratifying an amendment. The deadline to ratify the ERA has long since passed, and the amendment fell short of the required number of states. When proposing a constitutional amendment, the deadline for ratification is just as important as the substance. The District Court for D.C. less than 2 weeks ago denied an effort by Virginia, Nevada, and Illinois to force the adoption of the ERA despite the 1979 deadline. In denying the effort of those states, the court said that a deadline for ratification still receives the assent of 2/3 of both houses of Congress, and putting it in the resolving clause does not evade Article 5 procedural requirements in any way. Because setting a deadline takes a 2/3 vote of Congress, it would be absurd to say that changing that deadline requires anything less. If a simple majority of Congress could alter a proposed amendment after it has been sent to the states, the 2/3 requirement of Article 5 would be meaningless. A partisan majority cannot rewrite a proposed amendment at will after there has been an agreement in Congress. However, that's just what H.J. Res. 17 and the Democrats propose to do. The ERA expired in 1979, and this joint resolution is a legal fiction advanced for political purposes. I urge all members to oppose this resolution, and Madam Speaker, I reserve the balance of my time.